Hi. So the recent bankruptcy of Hudson's Bay has brought into focus again the rights of employees on insolvency of the employer or the lack of them. Now, there's something very important I'm going to mention at the end of this video. So please, by all means, stay tuned to the very end because there's an exceptional claim you can make if you're prepared and if you're smart. Generally speaking, all employee claims on termination of this circumstance are considered those of an unpaid general creditor. You're at the back of the bus with everybody else, and you're probably going to get nothing on those claims. However, there are certain protected claims available. First of all, if you were owed salary at the time of termination or unpaid vacation pay, and that's the vacation pay that the employer has agreed to provide, not the statutory minimum. You can make a claim against the directors personally up to a cap of 6 months' salary. You have to make the claim in the bankruptcy or the insolvency procedure to show you've done it and can't get paid, and then you can sue the directors. And additionally, in Canada, there's new legislation called the Wage Earner Protection Program that gives unpaid salary, unpaid vacation pay, unpaid termination or severance pay up to a maximum of $8,884 a person. So make sure you make those claims. In addition, in bankruptcy, there's a preferred claim of $2,000 for unpaid wages that comes ahead of secured creditors. So again, make sure you make that claim. Generally speaking, that's it. And you're not going to get much. However, there's another issue that I mentioned at the outset you should be very familiar with. And that is, on termination of employment, the benefit provider, the insurance company, has to provide continuity of disability benefits for up to 8 weeks. Now, there may be an issue as to whether the insurer has been paid. If the insurer has been paid and the coverage is in place, then there can be a claim made against the disability insurer, provided that you can show medical evidence of a physical or emotional disability that commenced within the protected period. Again, a cap of 8 weeks. It's basically 1 week a year, not quite, but one week after 3 months, 2 weeks after 2 weeks, etc., up to 8. But if you can show medical evidence to show that you were physically or emotionally disabled, either before the employment ended or during the protected period, if coverage is in place, you can make a claim against the disability insurer for up to age 65 or arguably beyond. So you need medical evidence to show when the disability began. So hopefully you can show it before the employment actually ended. So if you're so upset and frustrated, or you had an emotional breakdown or a serious physical medical issue, then you've got a good claim for disability benefits for as long as that disability continues. So please be aware of that. It's really, really important. A lot of people won't think of it, but you need current medical evidence. You need evidence to show when the disability started, either before employment ended, hopefully, or during the protected period if the benefits continued in place. And again, once you can show that, recurring medical evidence is required to show the continuity of the disability. Really, really important.